Hello and welcome to today's webinar. My name is Paula Price. I'm with People's Law School, and today we are talking about mental health and disability in the workplace. We have two amazing guests. I will be introducing them in just a few minutes, Paula Krauss and Laura Track. So you are in the right place if you want to learn more about mental health and disability in the workplace in BC. We are going to be talking about everyday legal issues related to mental health and disability in the workplace. We will be talking about the rights and responsibilities of workers and employers related to mental health and disability in the workplace. And finally, we'll be talking about what you can do if you have concerns about discrimination on the basis of mental disability. What you can expect, we have 60 minutes together, and we will be providing answers to your questions. And today's session is legal information, not advice. So if what you're looking for is the law as it applies to your particular set of circumstances, we invite you to reach out to a lawyer. You're welcome to reach out to one of our presenters. Their contact information is on the screen. We'd like to acknowledge that we are grateful to work on the unceded traditional territories of the Musqueam, Squamish, and Tsleil-Waututh nations, whose people continue to live on and care for these lands. And we invite you to, wherever it is that you're joining us from, to consider where it is that you are joining us from as well. We'd also like to thank our funders, the Department of Justice Canada, the Law Foundation of British Columbia, and the Notary Foundation for their financial support of today's webinar. And last but not least, I would like to welcome and thank our speakers. We have Laura Track. She is a lawyer and the director of the Community Legal Assistance Society's Human Rights Clinic and their director of education. Laura advocates on behalf of people who have experienced discrimination and assists complainants in navigating BC's human rights process. Laura is a return speaker to the People's Law School webinars, and we are delighted to have her back. Welcome, Laura. We also have Paula Krauss. Paula she's an employment lawyer. She is also the co-founder of Porta Law. She is an empathetic and thoughtful advocate whose work inside and outside of the courtroom promotes mutually beneficial workplace relationships. I'd also like to note that the Porta Law website is a wonderful resource for anybody who has questions about employment law topics. Paula, welcome to today's webinar. So we're going to start out with our first question, which is this. I sometimes struggle with depression and anxiety. Does that mean I have a mental disability? And Paula, this question is for you.
Thanks, Paula, for that introduction and for having us here. I'm really glad to be joining the People's Law School this afternoon. This is a question I get a lot from my clients, as I'm sure Laura does as well. I think recently, there are a lot of employees standing up for themselves when they are struggling with mental health problems like depression and anxiety. And it's not an uncommon place to be in. The short answer is if you are, the short answer is you have to talk to your doctor. A lawyer isn't going to be able to tell you if you have depression and anxiety or anxiety. You're gonna have to speak to your healthcare professionals. And if you are diagnosed provisionally or otherwise with depression or anxiety, then very likely, like 99%, I would say, because nothing is always 100% guaranteed under the law, but you know, that diagnosis will lead to protection under the Human Rights Code as you have a mental disability, which is protected under the Human Rights Code. Protection from discrimination is what I mean.
Excellent. Thank you so much, Paula. And just a follow-up question then. What does mental disability include? It includes depression, anxiety.
Yeah, mental disability under the Human Rights Code, there's two types that the Human Rights Code lists out: a mental disability and a physical disability. In order to get the protection from the Human Rights Code against discrimination, any kind of disability, whether it's physical or mental, has to be um, there has to be a degree of permanence, a degree of persistence to it, in the sense that it can't be something temporary or transitory, right? So there has to be a certain degree of severity to it as well, and it has to impede on, your ability to carry out regular functions in your life, which would include your work. There is no really clear line in the sand of what is that specific severity or that specific permanence, right? It's really, you have to look at your situation, at your health circumstances, at your working circumstances as a whole, and together, you know, together then, with your doctor and hopefully with the help of a lawyer, you could figure out whether you do have a mental disability that is protected under the code.
Super. Thank you so much, Paula. This next question is for you, Laura. And the question here is, what is the Community Legal Assistance Society? And what resources are available at the Human Rights Clinic?
Thank you, Paula. So the Community Legal Assistance Society is a legal nonprofit organization. We've been around for just over 50 years. We just had an anniversary party quite recently. And in those 50 years, we've been providing free legal services to people in a range of different legal areas, including workers' issues, mental health law, and human rights. The Human Rights Clinic is one of the programs or departments at the Community Legal Assistance Society, which we call CLASS for short. And at the Human Rights Clinic, we have a team of lawyers and legal advocates, as well as support staff that hold it all together, that provide free legal services to people who have made or who are thinking about making a human rights complaint to the BC Human Rights Tribunal. So we apply and work with the BC Human Rights Code and this definition of disability that Paula has explained to us every day. And we have a range of services available to the public, including an inquiry line that is staffed Monday to Friday, 9 to 5, where people can talk to a real live human about their situation and get some really basic information and guidance. We also offer what we call our short service clinic. The short service clinic operates every Monday and also on Wednesday evenings. And that provides a half hour of summary legal advice, either with a lawyer or an advocate, really more tailored and specific to the particular situation that a person might be experiencing. So we answer questions from the public at the short service clinic about whether their medical condition might constitute a disability for the purposes of the Human Rights Code. We can give people guidance and advice about whether the situation that they're experiencing could be a violation of the Human Rights Code, and if it is, how to file a human rights complaint. And then for those who have filed a human rights complaint and the tribunal has accepted their complaint for filing, we take applications for legal representation. We have lawyers and advocates that can represent complainants as the tribunal complaints process moves along, including at mediations and at other stages of the process.
Beautiful. Thank you so much, Laura. And I note that there was a link put in the chat, and we will be providing links along with the recording of today's session. This next question is for you, Paula. I took 6 months off to deal with burnout from my last job. Now I'm applying for work. How can I explain the gap on my resume? I don't want to scare off prospective employers.
Yeah, this is a tough question, and it's because it depends on individual circumstances and an individual's strengths in how they interview and how they present themselves. You might feel very comfortable depending on who you're interviewing with, if you know them well or you have a previous relationship with the person interviewing you or the employer. You might feel comfortable saying, I took time off to work on my health. Um, Now that being said, you don't have to do that. You're not required to. Under the law, you don't have to say that you were sick or you were on a medical leave. Your health status is normally not going to be at issue in an interview. There are some exceptions to that. If there is a real, genuine reason why your potential employer who is interviewing you needs to know about your health. For example, if you are applying for a position in a healthcare industry, for example, or in a for a position that requires you to, lift a certain amount, for example, on a daily. Those are there are circumstances where genuinely, in order to properly do the job in a safe way, a potential employer may ask you about your health status. But otherwise, the general rule is you don't have to answer those questions. And if you get questioned on that topic, I think it's a big red flag about whether this is an employer that you want to be working with. In terms of, a professional or personal business decision of how to explain a gap, I think there's lots of creative ways to go around that. I think that one of them, which is going to be true one way or another, if you have been on a sick leave or a stress leave, is that I had to take time to figure out exactly what I wanted, and I've been careful and meticulous with looking for a new employer and a new workplace where I want to thrive in and be healthy in. That's a good answer that I think will apply across the board if you're just coming off of a medical leave.
Beautiful. Thank you so much, Paula. Really helpful and lovely to have some ideas and suggestions. Laura, this next question is for you. Things are generally fine at work, but I struggle with alcohol addiction. Do I need to tell my employer I don't want it to be labeled or pigeonholed?
This is a great question, and really understandable that an employee would be reluctant or hesitant to share with an employer that they are struggling with a substance use problem. There is a lot of stigma associated with mental health issues in general and with addiction issues in particular. And it's also true that we've certainly seen some employers in cases that have gone to the Labor Relations Board or the Human Rights Tribunal, where employers have, in response to disclosure of a substance use disorder, either reacted very poorly in terms of termination or imposed incredibly onerous conditions on workers in order to remain in the workplace. Requiring them to attend residential treatment facilities, requiring them to submit to random drug testing for the next 2 or more years. And these reactions have happened even in situations where the substance use problem has never impacted the employee's work or productivity or performance. So it's understandable that someone would be cautious about disclosing a substance use issue to their employer. That said, some employers react wonderfully and supportively to a disclosure like that and may have resources available that a person can access to help them to deal with their substance use disorder. So it's a real difficult decision for any employee to make. As Paula, I think, said, in general, there is no obligation to disclose any disability to an employer unless it impacts on safety or unless a person is seeking accommodation for that disability. So if I have diabetes, for example, but it's not relevant to my work in any way, I don't have any obligation to disclose that fact to my employer. However, if I need an accommodation for my medical condition or my disability of diabetes. Let's say I need an additional 10-minute break every afternoon to check my blood sugar. Well, in that case, there would be some obligation to disclose enough information about my condition to allow my employer to understand what I need and accommodate me. So again, while the general rule is there's no obligation to disclose, if an employee is seeking an accommodation for that disability, then they need to provide enough information so that the employer can provide the requested accommodation. Maybe I'll just add one last point, if that's okay. In the case of an alcohol use disorder, the employee might not think that the issue is affecting them at work, but there are situations where an employer may identify some performance issues that could be connected to the issue, to the alcohol use disorder. And there's a concept in human rights law called the duty to inquire. If an employer has reason to think that an employee's performance issue might be related to a disability, like an addiction, like a mental health issue, then they have a duty to inquire about that possibility before doing something like disciplining the employee or terminating their employment. So if an employer observed a worker, I don't know, coming in late repeatedly with bloodshot eyes and smelling of alcohol, for example, before disciplining that person for their consistent lateness in the workplace, they would have a duty to inquire about what might be going on. And if that inquiry does reveal the existence of a disability like an alcohol use disorder, there would be a duty to accommodate that disability to what's called the point of undue hardship, and to take reasonable and practical steps to try to help address that situation and help the employee to recover from that illness of their substance use disorder.
Thank you so much, Laura. That is really, really helpful. Paula, this next question is for you. How do I talk about my disability with my employer? Do I need to do it in writing?
Yeah, this question definitely sort of I'll reiterate some of the things that Laura said in that this is very difficult for an employee as an employee to decide how to approach a discussion with your manager or your employer about your disability. There's so many factors that go into it, what your comfort level is, what perhaps your colleagues' experience has been, if they've disclosed disabilities before and asked for accommodations. I think that it is that you have to look at your circumstances and see how you feel the most comfortable approaching the issue. The best case scenario would be to speak in person, or if that's not possible because of the arrangement of a hybrid workplace or something like that, over the phone or video, but verbally to speak to your direct manager or human resources, if there is a human resources department at your workplace that specifically deals with these kinds of issues, and to verbally bring it up, and to do so in a way that is forthright, open, remembering that you do not have to disclose your diagnosis, or the details of your medical condition or your disability, but you should be disclosing, if you're in that position where you have to talk to your employer, what kinds of accommodations you're seeking and why, and how your disability is affecting your performance and your ability to do your job. So that discussion, in my view, I've seen a lot of success with employees and employers who both take an open and respectful approach to a verbal conversation. I think that it allows, people to really understand each other's tone rather than to have everything in writing right away and only in writing. It allows for empathy, or at least sympathy, and it allows for sort of questions to be asked by either side in that kind of more personal environment. So I think that having a verbal conversation is the way to go in an ideal situation, but I also think that it should be followed up in writing. I think that when you're talking about issues that are of this kind of importance, getting, you know, uh, talking to your talking to your employer to obtain, your legal right to an accommodation, you should follow up in writing a summary of what was talked about verbally. So, dear, employer, as we talked about today, I'd like to summarize. This is how I've been struggling at work. I do have a medical condition that prevents me from doing X, Y, and Z. This is what I have asked for. We've agreed to come back to the table and meet again on, in next week to make some plans, right? So a summary of what was talked about. And the reason for that is that it makes sure that there is a concrete communication that there's less likely to be misinterpreted once more people get involved. And it's a good reminder, right? It's a good thing to have notes about what was said and done by both parties. As a lawyer, we always look at what are the worst case scenarios. And the worst case scenario is that you might have to take some kind of legal action or have some evidence of what was said and done over a call. So it's also just good practice to have a written documentation of that. But in order to, approach your employer and talk about something that is really personal and can be difficult to talk about, if you can and if you feel comfortable enough, making that first approach verbally, I think is a good way to set the tone of the conversation, which should be a collaborative one.
Super. Thank you so much, Paula. And I think you might have mentioned this as well, but by having that written summary after the initial discussion, you give your employer, for example, an opportunity to say, yeah, exactly, that's what we talked about, or maybe there's something in there that wasn't quite clearly communicated verbally, but can then be clarified after that. So
exactly. Yeah.
Wonderful. Thank you so much. Laura, this next question is for you. Can you ask for accommodations without disclosing your disability?
So, like so many questions that touch on the law, the answer is it depends. The sort of general rule or principle is that an employer needs enough information in order to provide the necessary accommodations. They're not necessarily entitled to know a person's specific diagnosis. I think practically speaking, this can be tricky. In my previous example, it would be hard for me to ask for an additional 10-minute break every afternoon to test my blood sugar without disclosing my diagnosis of diabetes. But let's say that someone is requesting to leave a half hour early once a week in order to see a psychologist and get counseling for a mental health issue. In my view, an employer would not be entitled to know the diagnosis that a person has if they have a diagnosis of depression or anxiety or whatever it might be. It's sufficient for them to know that this person is accessing the support of a psychologist, they're getting counseling. That's enough information for the employer, in my view, to provide the requested accommodation. So the answer, as I say, is sort of it depends, but in general, no, you don't have to disclose your diagnosis or your treatment plan or your prognosis. You have to disclose enough information so that your employer can understand what barriers you might be experiencing in the workplace in connection with your disability and what they can do to address and remove those barriers to the greatest possible.
Super. Thank you so much, Laura. This next question is for you, Paula. How far does my boss need to go to accommodate me? I have ADHD and need extra support like reminders and regular check-ins.
So this is, there's a legal concept that I believe Laura has touched on called undue hardship. So an employer, when it's on the table. It's known that an employee has a disability that requires an accommodation in order for them to be able to fulfill their duties and responsibilities to the standard as expected and required. Once that's on the table, an employer needs to make reasonable efforts to provide an accommodation. An accommodation is going to look very different in different situations. Sort of the sort of most obvious example that I can think of usually is, if you have a broken ankle or sprained knee, you come into the office and perhaps, your employer provides you with a stool or a chair that you didn't have before because normally you're standing at your job, right? That's an easy thing to kind of see and understand and conceptualize. When it comes to mental health and mental disabilities protected under the code, it's a bit more difficult about what that accommodation can look like. Sometimes an accommodation looks like facilitating time off, a month or 2 months, right? Accommodation could look like helping, the employer doing their part on filling out EI forms or short-term or long-term disability forms, right? Other accommodations can be exactly what's on the slide here. Making tweaks to your schedule, your regular workday in order to accommodate your specific needs. So the example here for extra support like reminders and regular check-ins, most employers are going to be able to handle that kind of accommodation, right? Your employer has to continue to accommodate you up to undue hardship. That's sort of the end point. And that end point is in a different place for different kinds of employers. So if you work for an employer that has, 10 locations in BC, 5,000 employees over, in the province with a variety of different kinds of positions, it will be most likely, easy for an employer to accommodate needs like reminders, regular check-ins, perhaps more frequent one-on-ones, perhaps a 10 a.m. start time rather than a 9 a.m. start time, right? If you work for an employer that is a mom and pop shop that has 3 employees total, including the owner, then accommodations look different and the ability for your employer to accommodate you, it changes, right? So that point of undue hardship is when your employer has exhausted all their options, all their reasonable options, reasonable alternatives or ideas to how to accommodate you. It's a hard point to reach. There has to be some real efforts here made back and forth with the employee and employer to come up with reasonable accommodations. And it's usually pretty tough to prove for an employer that they've reached the point of undue hardship and they've exhausted all possible reasonable accommodations. And so, but it can happen. Accommodating ADHD, for example, like the example on the slide has here, that doesn't seem to me sort of, I can't think of a case where that would reach undue hardship. That should be doable in almost all cases.
Super. Thank you so much, Paula. Laura, this next question is for you. My boss is very hard to work with. It's taking a toll on my mental health. What can I do about it?
Yeah, it's a question that I think we're asked at the clinic pretty often, and it's not an easy one. It really depends on what your options are in terms of your particular workplace, alternative workplaces you might go. It's a really hard question, but I think, raising the issue with a trusted person in the workplace. Maybe that's a trusted coworker that you bring the issue up with to try to brainstorm strategies for dealing with the boss. Maybe there's an HR department where the issue can be raised. Maybe there's a formal reporting process. From the question, being hard to work with could encompass a whole range of behaviors on the part of the boss. Maybe they're just, really demanding and really drive their employees to work super hard and work long hours. And that's going to necessitate, maybe one strategy. Whereas a boss who's hard to work with because they are discriminatory and abusive and are bullying, that's going to necessitate a different kind of strategy. If a boss's behavior rises to that level of bullying or harassment, a WorkSafe report could be an option, reporting to WorkSafe that bullying and harassment is happening in the workplace. That's a workplace safety issue. So it's an issue that WorkSafe can get involved in some situations where a workplace has become so toxic and so unsafe that it isn't an appropriate working environment for staff anymore. So yeah, it's a really challenging situation. Perhaps the right outcome is that you need to leave this particular workplace. This is not a place where you're going to thrive, and it isn't a good fit any longer. But if there is a possibility for change, either through working with another coworker or through the HR department to try to address the behavior, that may be a possibility in some circumstances as well.
Super. Thank you so much, Laura. Paula, this next question is for you. My job is really stressful, and sometimes I dread it so much I call in sick. Can I get fired for that?
So this is also a it depends answer, which I know that people really don't like. But in law, so much of the answer to a question is going to depend on the specific circumstances of what's going on with you, and your circumstances are going to be different than your friends and your colleagues. So first of all, in BC, there are a minimum amount of paid and unpaid sick days that you're allowed to take. So we're moving sort of away from the Human Rights Code and into the Employment Standards Act, and that legislation protects a total of 8 days of sick, they call it injury or illness leave, 5 paid, 3 unpaid. So at a minimum, at your job, you are entitled to 8 days of sick, eight sick days essentially, and you are not allowed to be retaliated against, fired, or otherwise negatively treated at work because of those sick days. Now, your employer may ask for some kind of proof that you're sick and you're not abusing those sick days when it comes to dealing with stress and taking sick days for mental health. In a minimum amount, like in a not often, but maybe sometimes you may have to get a note or something like that from your doctor to show that, although those situations where you have to do that are going to be very limited. If you need more time off from your work, more than 8 days, then you have to start looking at, okay, what are other entitlements that my employment contract allows for? Maybe there's a sick leave policy that allows for 15 days of sick leave, or maybe it's 10, right? Maybe that's your sort of first line of inquiry is, what else am I entitled to? Because as long as you're taking sick days that your contract allows for, or there's a policy that allows for that, and you actually are using those days as mental health days, that shouldn't, you shouldn't get fired for that. And if you do, then that's a problem, and you should go see a lawyer about what your rights are. If you are at a point where you're requiring, a bigger chunk of time off, the question then becomes, does your employer have to accommodate that, right? Accommodate meaning allowing you to go off for a 2-month stress leave. And so your employer has to accommodate that if your health condition amounts to a mental disability under the code. So like we talked about before, there has to be a certain permanence, right? It can't just be a transitory thing like the flu or a cold. It has to amount to a certain sort of level of severity, right? It has to prevent you from being able to normally carry out the functions of your job, right? Your life, but your job. At that point, you have to involve a doctor. You have to go to a doctor, and you have to have a doctor assess you. And in my practice, what I've seen is that most people who do go see a doctor and they receive a note or a letter that describes a medical condition caused by stressful workplace that requires time off, most employers are going to accommodate that. And if you get fired for it, you're going to have to, you've got several options there. And before making a decision about your options, it's a good idea to see a lawyer about your entitlements. So the answer is, it really depends. If that stress has amounted to a mental disability that is protected under the Human Rights Code, you can't be fired for it. That doesn't mean you won't be. Some employers just don't do what, don't act in a reasonable and lawful way. And that is the worst case scenario. In most cases, there's going to be some kind of accommodation for you to take the time off.
Super. Thank you so much, Paula. I'm just noting the time. We've got a few more prepared questions, and so we'll go through those questions and then turn to some of the questions that have come in through the Q&A function. Laura, this next question is for you. I want to go on stress leave, but I'm worried about how it will affect my career prospects. What should I do?
Yeah. This question makes me think of the earlier question that Paula answered around, explaining a leave in an interview. And I think, I would encourage folks to think about how will it affect your career prospects if you don't take this leave and don't take your mental health seriously and get some support, get a rest, whatever it might be, by taking this leave. So, your career is one part of your life, and your health is just such a critical part of your well-being and, all of those other important parts of your life beyond just your job. How is all of that going to be affected if you continue on in this stressful workplace situation? I would just add to that this question about stress is one that we see a lot at the Human Rights Clinic, so much in fact that we wrote a blog post about it, which might be shared in the links that are circulated to folks later on. In general, the Human Rights Tribunal hasn't treated stress on its own as a disability necessitating accommodation under the Human Rights Code. However, stress can certainly be a symptom of a disability, like an anxiety disorder, like post-traumatic stress disorder. And that stress is showing up in the workplace as a sort of manifestation of an underlying disability. So as Paula said, seeing a medical professional to determine what may be going on can be really essential to grounding a duty to accommodate under human rights legislation. But what I also often say is that the Human Rights Code sets the floor, not the ceiling. An employer may not have a legal duty to accommodate under human rights law someone who's experiencing stress, but they certainly can accommodate in the sort of lowercase a sense by providing a stress leave, because they recognize that employees are their best selves at work and most productive and happiest and healthiest when they have access to an opportunity for a bit of a break. So even if stress on its own may not be a disability requiring accommodation under human rights legislation, we would encourage employers to take those needs seriously, even if they don't sort of rise to the level of a disability.
Beautiful. Thank you so much, Laura. Paul, this next question is for you. I don't think I can afford to take time off. Is there financial support for people like me?
Yeah, that's a really big factor in deciding what to do and how to manage your health. So the first thing that I normally recommend is to look at what your employer provides as health benefits. So you may be receiving extended health benefits. You may be receiving paying into short-term and or long-term disability. Those types of benefit insurance policies are usually the best in terms of replacing your income while you're off. Your employer, when they do accommodate you and allow you to take some time off, they are not required, unless there's something else in your contract that says so, but they're not required to pay you your regular pay for a 3-month leave, right? They're required to accommodate you, for example, to take that time off, but unpaid, right? As long as you've exhausted all your other paid leaves, sick leave entitlements. In any event, if you've got short-term or long-term disability through your employer, that's usually the first place to go and get that process started right away once you know that you're going to need to take time off. If you've got a human resources department or manager at your workplace, that would be the point person. Otherwise, it would be your manager. And also, just getting your own policy information and going to the insurer yourself, logging on to your sort of online portal, you can get that process started. If that's not available to you, another option is to look at EI, employment insurance, that framework. There are sickness benefits, sickness EI, and that process normally involves your employer, filling out a record of employment and your doctor filling out a medical certificate to certify that, you are in fact sick and do need benefits. Those benefits will replace a portion of your income, which is usually a lower portion than a private short-term or long-term disability program would provide you with. Another option for financial support is WorkSafe. That is available if your need for time off is to manage or recover from what WorkSafe calls a psychological injury. And that is an injury you sustain in the workplace that is of a mental health nature. Right? So it's not that you slipped and fell at work or, on a construction site, a beam fell on you and hurt your shoulder, or, you have or problems with like ergonomic problems because of, being at a desk all day. Those are physical injuries, right? WorkSafe also deals with what they call psychological injuries. I think that's what they call them. And that's the mental health injury. So if you have sustained, PTSD or suffer from anxiety or depression because of workplace stressors, because of bullying and harassment at work, then an option for you is to file a claim with WorkSafe BC. And if they accept that claim, then you will receive benefits. The process to review the claim and to sort of analyze how much and how long you'll be receiving those benefits for is can be a webinar all on its own, but to summarize, if your claim is accepted, you would be entitled to wage loss benefits, so to replace your income, and also other kinds of health benefits, to rehabilitate you and get you back to work.
Super. Thank you so much, Paula. Laura, this next question is for you. I talked about my disability with my employer. They said all the right things, but now I'm being treated differently and maybe even pushed out. What can I do about it?
So this is sort of trending into territory where you may be thinking about litigation. And so our advice at that stage is to document everything. Paula talked about, following up on accommodation requests and, verbal discussions with a letter. If you're finding that you're being treated differently, you're feeling like you're being pushed out, document what's happening. Take handwritten notes, ideally that have a date and that record what you're experiencing. Raise it with your union if you're fortunate to have a union. Raise it with the HR department if you have that. And if you can, let the employer know how you're feeling. They may not realize that their actions are having that impact on you and that you're perceiving their actions as an attempt to push you out. Unfortunately, most employers don't get any training before going into business on their human rights obligations or on their duty to accommodate. And you may be the first employee that they've ever been asked to accommodate before. That's really scary and a really brave thing for any employee to do. The employer may be figuring things out as they go. They may have good intentions, but it comes across like they're dragging their feet, where from their perspective, they're just trying to figure out what to do. So to the greatest extent possible, try to keep an open dialogue with the employer going. Keep letting them know what you need, how you're doing, and how the accommodations that they've offered are working or are not working for you, and document your efforts.
Super. Thank you so much, Laura. So we just got a couple more questions, then we're going to turn to the live Q&A. Paula, when's the right time to reach out to a lawyer?
The right time to reach out to a lawyer is when you don't know what to do next. Different people will have different thresholds of how much they can go out and learn and figure out on their own online with different resources that are available. But when you are making decisions based on information, when you're making decisions that you don't have sort of an informational basis for, you should get some help. And that really, it can be at a different point for different people, right? For some people, they're well equipped to talk to HR, to deal with HR, to deal with their employer, to document what's happening, to search out, online resources and take the next step in the accommodation process or whatever situation you're having at work. Other people, for many different reasons, perhaps it's a disability that's preventing you from, advocating for yourself as your colleague might, right? So the time to see a lawyer is before that. As soon as you feel like you can't advocate for yourself or you don't have the information to make an informed decision, that's when you go to see a lawyer.
Beautiful. Thank you so much, Paula. And then Laura, this last question is for you. I don't think I can afford a lawyer. Are there any low-cost options?
What a great question. Well, if it's a human rights matter, our clinic is free of charge and anybody can access the short service clinic that I mentioned at the beginning of our presentation together, which is the half hour of summary advice every Monday and also on Wednesday evenings. There's no application for that, no income threshold or screening that happens for that service. We also often recommend that folks visit Access Pro Bono, a really amazing organization that can provide broader scope of service than what our human rights clinic can do. Access Pro Bono has a roster of lawyers, including employment law lawyers, that can give you advice and guidance for free at various junctures in your employment relationship. They've also just developed an articling student-led clinic called the Everyone Legal Clinic. That's another great resource handling some employment law matters. I believe some employment lawyers in private practice offer free or low-cost consultations. And so that could be an option to explore. And we also have a page on our website with free and low-cost resources that folks can check out as well on the BCHRC website.
Beautiful. Thanks so much, Laura. And we will provide links to those along with the recording of today's webinar. I'm going to start with a question that came in from an anonymous attendee that received the most upvotes. What kind of accommodations can you get for ongoing depression and anxiety? I usually just take sick leave when I'm having a really hard time and need a mental health break, but I end up using all my sick days. I've often thought if I could work less hours per day on a part-time, that might help for a period of time until the episode passes. Would this need to come from a doctor? I've already had my doctor write a note advising that I have depression and anxiety. Laura or Paula, who would like to answer the question?
I could offer a thought. First of all,
Beautiful.
accommodation possibilities are endless and so unique and varied. What's possible and reasonable is going to depend on the nature of the work and the workplace and on the person's disabilities and their disability related needs. So absolutely what you've proposed is something that you could ask about as a potential accommodation from your employer. I think it would be helpful to provide medical information in support of that request, something from a doctor to say like, yes, this would be a really beneficial option for this person to have if and when they are experiencing a depression episode. And an employer would need to take that request seriously and consider whether they could make that accommodation without experiencing an undue hardship given the nature of the work in the workplace.
Beautiful. Thank you. And Paula, would you like to add anything or would you like me to go
Yeah,
to the next question?
I think the one thing I would add is to reiterate what I said before about sort of approaching your employer with openness, and when there's space there for that accommodation process to be collaborative, which it's supposed to be, you might be surprised at the good ideas an employer might bring to the table, right? Maybe it doesn't work to be part-time in terms of 9 a.m. to 3 p.m., but maybe Monday to Thursday works for the employer, or maybe a hybrid work arrangement where you're working from home and not in that environment that stresses you out directly. So there are, like Laura said, endless possibilities. And as long as your doctor recommends and supports that accommodation, if it's one that is a drastic one, for example, and it's reasonable for an employer to ask for that, it's you can cater these to what your health needs are.
Yeah. Beautiful. Thanks, Paula. And Paula, perhaps I'll ask you this next question. Is unaddressed workplace bullying part of mental health leave? And then in brackets, is it considered medical leave or sick leave?
Yeah, a medical or a sick leave isn't determined by what caused the health condition. It is because of the health condition itself, right? So whether let's say you are suffering from anxiety, whether that anxiety is caused by the workplace or caused by an outside factor like something happening in your family, or maybe it's a chronic condition, that doesn't determine whether you're allowed to take a sick leave or a medical leave or get protection under the Human Rights Code for it. What does make a difference if your mental health is caught, like if you have a medical condition that's caused by workplace stressors, then that determines whether or not you might, for example, what kind of accommodation you're looking for, right? The type of accommodation you're looking for, or because you can go on a stress leave and then come back into the same exact awful environment, right? The accommodation is at that point going to have to involve a change in the work environment. It also determines, whether, for example, you are entitled to WorkSafe benefits, right? Whether you fall under a workplace injury claim. And it also determines whether or not, you might be, this is on the very extreme, but, might be in a workplace, sort of a toxic workplace environment that amounts to, a dismissal, that you have to leave against, not because you want to resign, but because you have no choice to. So that's where those considerations come in of what's causing the medical condition.
Beautiful. Thank you, Paula. And we're almost at time, but Laura, if you have a moment to answer this last question, following up on something we talked about earlier, regarding the duty to ask before discipline, does this mean a generic ask, such as, is there anything that is preventing you from attending work each day? Or should the question include specific language, such as, are you struggling with a health or addiction issue?
There's no real one size fits all. And I really recognize that could be a very difficult conversation for both parties. It can feel awkward. We've talked about how mental health issues and substance use disorders are incredibly stigmatized. And there can also be denial involved on the part of the person who may be struggling. What an employer needs to do is identify what they've observed. I've observed that you have been late for 5 out of the last 6 days. And the other day, it seemed like you were really out of sorts, and I thought I might have even smelled alcohol in your breath. Is there something going on? What's going on? You identify the observation and give a person an opportunity to identify and flag that, yeah, there is something going on here. That then allows you as the employer to take the next step of exploring what might be possible to provide a reasonable accommodation. So I don't know if that's as direct or specific as the inquirer was hoping for, but the main goal is to provide an opportunity for an employee to identify that, yes, there is a disability here, there is a code protected characteristic at issue, and therefore a human rights obligation to provide some accommodation.
Super. Thank you so much, Laura. I would love to know from each of you whether there are any additional comments that you would like to share that maybe we didn't get a chance to really touch on today, or that you'd like to highlight. And Laura, I will start with you. Would love to hear from you.
Thank you for the opportunity. And I don't know if Daria is still on the line, but I think Daria asked a question in the chat about whether as a casual worker, they were entitled or allowed or able to ask for accommodations. And the answer is yes. The Human Rights Code applies to workers regardless of their employment status as full-time or part-time or casual, or even volunteers, people who are working in a workplace but maybe not getting paid for that work. They're interns or volunteers, all have entitlements under the Human Rights Code. Now, someone's employment status might influence what a reasonable accommodation would be and where that point of undue hardship might lie for the employer. But just because you are casual or part-time doesn't mean that you have no right to seek an accommodation in your employment.
Beautiful. Thank you so much, Laura. Paula, is there anything that you would like to add or anything in particular that you'd like to highlight from our webinar today?
Yeah, I think that I have said this quite a bit, but sort of to end it on this note, I see the biggest breakdown in the accommodation process when one or both parties want to keep as much information to themselves as possible. And a productive accommodation process requires both parties to come to the table and be open about what they need, what they want, what they cannot provide, and what's reasonable in the circumstances. And it's a process of give and take. An employee isn't, you're not entitled to the best and your first choice accommodation. You're entitled to a reasonable one. And that's not going to take one meeting, 15-minute meeting one-on-one with your employer. That's going to take some back and forth and some give and take. And just to be open to that, because that process is going to give you the best outcome.
Super. Thank you so much, Paula. And thank you again, Laura, for joining us here today. Thank you to everybody who was here today. Thank you to the People's Law School team who's been providing answers in the chat and the Q&A as we've been going through today's session. With that, we're going to wrap up, wishing all of you a very good mental health week. It is Mental Health Week here in Canada, and delighted that we have this opportunity today to dive into this very important topic. Thank you again to our speakers, and very much look forward to reconnecting with you all at future webinars. So thank you again, and bye for now.